Welcome everyone to this, our latest webinar in the GW Law School, a series of interesting webinars we've held on various issues in public procurement. This one, as many of our sessions have been, is going to be focused on protectionism, what we call new protectionism. There's a new phase of protectionism coming. We're going to be talking about U.S. protectionism under Buy American initiatives in the Biden administration. We're going to be talking about two very important initiatives in the European Union, the IPI, the International Procurement Instrument, and then a separate measure that's still under review that would impose, that would address subsidies in foreign contractors. We'll also be talking about important developments in protectionism in Switzerland. It's a very interesting and important case study as protectionism emerges in a new phase around the world. I'm going to turn it over to Desiree Klingler, who has in the past helped me. She's a graduate of Yale Law School. She is teaching at Hamburg University. She's getting a PhD at the University of St. Gallen. She's a wonderful colleague to have involved in our programs, and I'm very, very grateful she could join us today. Desiree?
Thank you so much, Chris, for having me, for co-moderating today with you and Robert Anderson, which is an honor. As already Chris just said, I'm a research fellow at Yale Law School right now and a PhD candidate at the University of St. Gallen. And I would like to, Chris, if you could flip one slide forward, to remind you that we have a recording of today, that you will find the materials, etc., on my website, but also on a Public Procurement International. There are also articles posted that you might find interesting in relation to today's webinar. In terms of the questions, please use the chat, not the Q&A. We'll try our best to answer it during the webinar. And I would like to just briefly mention that all panelist statements are in their personal capacities. With having said this, I would like to briefly introduce the co-moderators and then go over to the panelists, a great panel we have today, and moderators, of course, as well. Chris Hukins, he's an experienced professor of public procurement law from George Washington University for many years, and he is the host of today's webinar. He has written a recent article on the Inflation Reduction Act that is related to what we discussed today. You might find that on the website. Thank you, Chris, for having me again. And then, of course, Robert Anderson, a very experienced member of the WTO Secretariat, former retired now, but still very active. And he is an honorary professor at the University of Nottingham in England. He will be speaking about the international perspective and the WTO and the GPA, which we are very excited. Then I would like to go over to introducing our panelists of today, starting with Simon Evenet. He is a very experienced professor at the University of St. Gallen, my alma mater, so I'm very excited to have him here. And he's also the founder of the Global Trade Alert, which is a groundbreaking tool that measures different trade measures, including protectionist, also in the field of public procurement, which we'll be talking about today, in real life. So, and he statistically analyzes those measures, and we are very excited to hear about those today. Then we have Laurens Abutalib. He is the representative of Switzerland, together with Simon Evenet, of course. He will be taking a political angle on today's topic, IPI and foreign subsidies. He's a political scientist. He's the founder of Politaris, that does a company that does polit monitoring, and also of the Alliance of Progressive Procurement in Switzerland. Very excited to have you here. And then we will hear from our third panelist, Eike Klepper. He is a diplomat of the European Union, currently based in Washington, D.C. He will be sharing the European perspective on what we're discussing today, IPI and subsidies, but also share some views on the Buy American, Buy America rules and the investment and Infrastructure Act that has been recently adopted last year. We will hear the other side of the coin from our very experienced former U.S. Trade Representative, Jean Hellman-Greer. She will be sharing what this means from a U.S. Perspective. She's also the lead consultant in her consultancy, Jage Consulting. So very excited to have this exclusive and very experienced panel here. Maybe we can switch over to the next slide. I have already mentioned what the different angles are going to be. So I would like to give some few introductory thoughts that we might carry through that webinar. Chris, if I might switch to the next slide. Thank you so much. So just a few thoughts that we will probably see that will be covered in today's webinar that I have called 3 areas of tension, or maybe not. We will discuss those, a red thread. So the first element, of course, is protectionism versus free market access. We have the different measures that have been introduced by American Act regionally and nationally. The IPI in the EU that we are discussing today, and also Switzerland that has taken similar measures along the EU and also the UK. So this perspective will be kind of the new protectionist angle of our discussion. And then we have the international part, the WTO agreement, and also a negotiation or potential accessions of China, Brazil, and Russia that have been going on for many years, and that play a big role in this new protectionist measures angle that we're having today. The second thought, and I think this is also represented by the panelists that we have today in our panel, is it a legal or a political instrument that we're talking about? And I think we can all agree that most likely both, but there is a strong political angle that we see. Buy American has been used as a politicum by the Biden administration. But if we take a closer look, the Buy American Act only covers 1% of the total federal procurement in the United States. So this makes us question what is actually the real impact of these Buy American, let's say, nationalist, protectionist, not nationalist, but protectionist measures that we're seeing. Then also question of does the WTO GPA trump the Buy American legislation? We will have thoughts on that from Eike and Jean. And then we also see many waivers for EU contracts due to public interest, non-availability of produce and services, and high costs. So there are actually many things that speak or kind of alleviate and constrain the protectionist measures, which goes into one of our questions that we're discussing today. Last but not least, protectionism and sustainability. So for many years, sustainability has been seen as a protectionist measures where certain local ideas could be promoted by. But what we see now is, can it also be a market opener? For example, in the United States, that is procuring now more renewable energy produce and services like wind turbines. We see that those are imported from the EU and not manufactured in the US. Does it mean that we have more free market access, a more liberal market? And does sustainability help to achieve this? So with these thoughts, I would like to give over to Chris Eukins, and very excited to be hearing from the panelists very soon.
Thank you so much, Desiree. And before we hand it over to our panelists, I just want to tee some things up for our audience. Now, we had registrants from 68 countries from 6 different continents. So really a worldwide audience, and I'm very, very grateful for that. There are some issues that are going to affect contractors from all over the world as they move into the European market and into the US market. Now, at the end of today's program, I'm going to give a link over to a session that we're doing next week on September 13th at noontime in Eastern time. It's through the American Bar Association, to discuss the Buy American provisions of the Biden administration in more detail. They're very complex, but as Desiree hinted at, they have an important interplay of sustainability. So one of the things that I wrote about in a recent piece that's on the program page is that the Biden administration had to take a step back on protectionism in order to accommodate solar technologies that are an important part of the global warming initiative under the Inflation Reduction Act. So there's an interplay here in the United States as well, and we'll be discussing that and the other Buy American provisions in more detail on the 13th. And I know ICA is going to be discussing them today. I did want to highlight just a couple of things to sort of set the stage with regards to the International Procurement Instrument, the IPI, and the Agreement on Foreign Subsidies. So the IPI is, as of June 23rd, it is now the law in the European Union, and it has a very important impact potentially on vendors from countries that are found not to have entered into fair trade agreements, opening procurement agreements, in trade agreements with the European Union. So we'll be discussing it in more detail for American vendors and also for folks around the world who may be working in the European Union. Very important to keep an eye on that, on the International Procurement Instrument, and to understand what it means. And we'll be talking about that in more detail. The other initiative is the Agreement on Foreign Subsidies. And what it does in essence is it applies European state aid rules, or would apply, as it's still it's still being developed within the European Union, but the provision on with regards to foreign subsidies would apply European state aid principles to a number of different areas, including mergers and acquisitions, but importantly would also apply to procurement. And so that is something that's coming over the horizon that we want to keep a very careful eye on. So with that, I'm going to turn it over to our speakers and start off with Rob Anderson, our co-moderator. Rob, thank you.
Thanks so much, Chris, and warm thanks to you and Desiree for involving me in this exciting and timely discussion with all the great panelists. So I just want to offer a kind of complementary perspective here. I suggest that all government measures bearing on trade, and including very much in government procurement markets, should not necessarily be viewed as protectionism. And rather, we actually have to look to the nature, purpose, and likely impacts of the measures. So, and in this case, my suggestion would be that the measures under discussion, and I'm thinking especially of the EU IPI, but also the others, arguably respond to legitimate concerns for the international trading system. And those include free riding on government procurement market openers, that is, the countries that do open their public procurement markets to international trade, at least partially. And also the problem of unfair and inefficient subsidies. And this is a problem that the world and the international trading community is concerned about. So I don't think we should rush to the conclusion that these are kind of illegitimate or protectionist measures. I also would make the point, and like the approach, I mean, as I think many participants in this program know, the US itself has what has been called a walled garden system, whereby only suppliers from countries that either are parties to the WTO agreement on government procurement or are parties to regional trade agreements embodying similar disciplines can bid on contracts in the United States. This in itself creates a powerful incentive for countries to join the GPA and or to negotiate similar bilateral or regional instruments. And it's arguable that, I think it's kind of evident from the face of the IPI that it is intended to have this effect as well. Now, this is not to say that there are no risks associated with these instruments. There are always risks, and right now is a time in the world where a lot of unilateralism is going on. And as I think other panelists will tell us, there's a lot of protectionism in public procurement markets. There's no question about that. have been progressive efforts to strengthen the implementation of Buy American measures in the United States. And all of these things do pose potential concerns for the international trading system. There's also, yes, there's also a dimension of bureaucratic burden involved with procedures, with writing legislation, and then relying on the waiver system to avoid the most pernicious effects of the legislation. So this is a potential problem as well. You know, I'm going to end by saying what I really think is needed is a renewed effort to collaborate on these issues at the multilateral level. And by the way, you know, it's possible, it's entirely possible that the current EU measures will help to move us in that direction. In the past, you know, experience has shown that the US, the EU, the other major countries of the international trading system are able to collaborate on some of these issues. And the GPA, the Government Procurement Agreement in 2012, was substantially modernized and strengthened as an instrument of good governance as well as market access. I think the time has come to also engage the GPA as an instrument for the promotion of sustainability. The idea of working on these issues concerning, you know, the wind turbines and climate change, it's time to bring those issues into the discussion of the future of the GPA. At the same time, a huge amount of work has been done on the possibility of China's accession to the GPA. I appreciate, having worked on that myself, that this is an enormously difficult challenge, even technically, let alone politically. But that's the way that meaningful progress really will occur on these issues eventually, when the major trading powers of the world come together to and again discuss and adjust and modernize the present international legal instruments to take account of, to bring China and other emerging economies into the group, to ensure that the GPA also functions as an instrument of sustainability in addition to market access. This is what we need, where we need to go in the future. Thanks very much.
Thank you so much, Robert Anderson. I couldn't stress it more what you mentioned. I think there will still be many risks or like challenges to overcome when it comes to sustainability and market access, if they're like antagonists or if they're actually complementary and so on. So, but I think that will be a very interesting discussion for the next revision of the GPA that we're most likely going through in the near future. At this point, I would also, before giving over to our next speaker, to our first panelist, introduce Michael Bauscher. That has slipped my mind. I'm very sorry. He's the Queen's Counsel at Montague Chambers, and I would also give him a warm welcome. He's the visiting professor at King's College London and will be sharing with us the British perspective on the IPI and the foreign subsidies and buy British, for which we're very excited and thankful. Thank you so much. Having said that, I would like to give over the word to Simon Evanet, who will be speaking about his most recent findings regarding the global trade alert in public procurement. Thank you.
Thank you, Desiree. My task is to summarize the volume of developments that we have seen in public procurement measures. I will focus on the period from the beginning of 2020, since this is the pandemic era and its fallout. What I will do is to give you some statistics on the number of public policy interventions which have altered the relative treatment of domestic versus foreign suppliers or vendors. So I'm not going to use the P word. If you think that shutting out foreign vendors is protectionist. That's for you to say. What we do in our team is we look for change, for policies changes which alter relative treatment of different types of vendors. That's the metric that we use consistently in our work. Now, since the beginning of 2020, we've managed to record 213 different developments around the world. These developments, 198 of which have favored local firms over foreign firms. So the overwhelming majority is in favoritism. The measures which favor local firms have been implemented by 45 jurisdictions, and 14 of the G20 countries are among the 45. So this is not just a localized phenomenon. It's not a phenomenon associated with any of the big power, just with any one of the big powers. It's quite broad. We have also been able to track how much trade is covered by public procurement measures. And the public procurement measures which were in effect this morning, we estimate cover about 4.8% of world goods trade. And since there's so much attention since the pandemic began, we estimate that around 11 to 12% of world biologics or medical trade is covered by some type of public procurement measure that favors local firms. And those percentages relate to public procurement measures which have been implemented since the beginning of 2020, but also predate 2020 as well. But they had to be in effect as of today. So you could see that this is for a global point of view, this is a serious problem. It is something therefore worthy, I think, of deliberation in trade fora such as the WTO. I also want to emphasize that one of the things we're seeing is countries rowing back from extremely aggressive protection or favoritism of local firms. And an excellent example of this is India, which in 2020 put in place restrictions which made it very hard for foreign medical suppliers to sell to New Delhi or sell to Indian public bodies. At the beginning of this year, in January, the Indians realized that they could not get their hands on enough medical devices, and they now allow bids for 128 different types of medical devices. And in June of this year, they expanded that list to 371 different types of medical devices. So what they're now doing is essentially rowing back the original measure that they put in place in 2020, largely on security of supply grounds. And I think this is an important lesson, and it chimes, I think, with what Chris was saying earlier about how sometimes in the pursuit of a particular social objective, governments have realized that they can go too far in favoring local firms. The deeper point there, I think, is that incentivizing supply by local firms does not necessarily create it in sufficient quantities. And at some point, the other objectives of public procurement must come back into play. To what extent are the goods actually being supplied? In this case, the Indian case, in the case of medical devices, the clearly very serious matter. We've also seen India row back its procurement restrictions in the area of potash and fertilizer this year as well. Sorry, that was in 2020. Anyway, given what's happened this year, ensuring that you've got sufficient fertilizer to help maintain food supplies is a critical matter in many countries, and in particular in India. So it's not all bad news, but I think there's an important lesson here that governments can go too far, and they are prepared to reverse course. I think this is very important in discussing public procurement matters, because often one hears from analysts and commentators that it's obvious that governments will only want to spend money on local firms. But when that policy either fails to deliver the goods, literally, then of course it's time to think again. And I think that's exactly when we should come in and have discussions about the design of national systems, as well as the value of international disciplines in this area. Let me stop there. Thank you.
Thank you so much, Simon. I think this is very interesting. The data basically show what our gut feeling is. And I think this is why the global trade alert is so important. It shows the facts, it shows the data, what is actually happening in real time. So like this example of India that was just a perfect example of what Chris was describing in the beginning. I don't want to put you on the spot, but I know that you're also looking into subsidies and the number of subsidies. And do you have anything to share about that, since we also talking about the foreign subsidies and how they might have a distorting effect on certain procurement markets?
So let me say that, I mean, last year we put out an extensive report on the subsidies awarded inside the European Union, the United States, and China. And all of these three jurisdictions are actively using subsidy policies across a wide range of goods and services. So the fact that there is a subsidy dimension to procurement discussions does not surprise me. But I'd highlight to any official from any of those three jurisdictions, they're all at it. And so if one jurisdiction starts targeting another jurisdiction's suppliers, one might expect a certain degree of reciprocity of the wrong type or retaliation of the wrong type. And so this is an area where I think holier than thou attitudes by officials are not warranted. We have a serious subsidy problem in the world. We need an informal or a formal dialogue on this to get some type of norms reestablished. And the sooner that happens, the better.
Thank you so much. And if I may just add one more point or ask you one more additional follow-up question, friendshoring, your global trade alert and report, and your colleague has written on that. Do you have any thoughts to share about that in relation to whether or not and how it relates to protectionism?
Okay, well, friendshoring is our policies which seek to move factories from less reliable, apparently, suppliers to allies. And clearly this must have some implications for public procurement. I mean, what my colleague Hallie Talbot did in the 3 briefing papers was to go through I think in a very balanced and systematic way, looking at this. And there are clear perils, as he highlights, in these policies, which could easily morph into further discrimination against foreign suppliers. And that's even before you start asking the question, who's an ally and who's likely to be an ally after the next presidential election or after this election or that election. So I think there's interesting questions as to what assumptions people are making about who are the allies around the world and who can be counted on.
Thank you so much for all this insight. Chris, do you want to add anything, or yeah?
No, please. Go ahead.
So then I would like to give over the word to Laurens. He will be sharing with us, I would say, a more political perspective on these different instruments and potential protectionist measures from Switzerland. Thank you so much for being here.
Thank you, Desiree, for allowing me to join, ladies and gentlemen. Warm welcome from my side, as maybe the image on the left is a little bit misleading, because Switzerland is actually full of infrastructure, highly densely built infrastructure, and public procurement makes a big piece of the GDP. The public hand purchases products and services about 45 billion Swiss francs, which makes 6%, 7% of the annual GDP of Switzerland. And coming to the public procurement revision that was taking place, or still taking place in Switzerland, came into effect on the 1st of January 2021 for the federal level. And that brings me to sort of set a little bit the stage, because Switzerland is a bit of a particular case. We have a strong federalist system. There's the federal government and 26 cantons, which more or less function independently next to each other when it comes to public procurement. On the federal level, we have a bicameral system of parliament, like in the US, and this constitutes kind of pros and cons when it comes to open markets. As you can imagine, Canton of Zurich might want to keep the bidders from the Canton of Aargau out of their markets and so forth. So even within Switzerland, there's a very strong competition, which is also reflected in the fiscal system. Policy-wise, when it comes to public procurement, there are three dimensions. Federal law, which is only applicable to federal procurements. There's the intercantonal agreement, which cantons sign voluntarily to agree to coordinate the legal framework among each other. And then based on that agreement, there are cantonal legislations which implement the agreement. So in fact, we have 26 plus 1 different public procurement regulations. And that was one of the major goals for the revision, also to get this harmonization going. From the politics side, there are several salient issues which I personally observed during these times of the revision. They do not just apply to public procurement in general. One is, of course, the sustainability, how to integrate more sustainability into society and the purchases. And then how can small and medium enterprises, national small medium enterprises, be better included into public procurements? So even despite their size, they have a chance to win a bid. And then the third is low fees around the markets, because there has been a very strong price competition, maybe less so compared to other countries, but nonetheless. And I assume those three issues were predominant when it came to the revision. So as I mentioned, the goals for the revision of the public procurement law in Switzerland was twofold, basically. One was the adoption of the revised WTO GPA agreement, which had to be adopted, the changes, and then also, like I said, the harmonization between federation and cantons, but still in separate legal frameworks. They tried to make one framework, the cantons resisted, so they stick with two. And they tried during the whole process on the federal level, the cantons sought to adapt their draft of the agreement, so to have the maximum of harmonization between the two levels. And that brings me to this, there's only one real element which has protectionist, very strong protectionist flavor. This is the adjudication criteria of different price levels compared to other countries. As you know, Switzerland is a high price country compared to others. Hence, when it comes to evaluating the price, an international competitor will most certainly win the bid, the contract. And out of this worry, there was a movement from social and an economic movement to implement this measure. And it was then adopted, but with an explicit mention that it has to happen within the international obligations that Switzerland has, speaking the WTO GPA agreement and the bilateral agreements with the European Union, which is interesting, because then what's the purpose if you cannot apply it to international? But that's a typical Swiss thing, to make compromises such that they are then sometimes not applicable. As said, it's highly controversial. It was the piece of resistance during the debate in the federal parliament. It almost destroyed the entire attempt to, it threatened the entire attempt to make the revision. And the cantonal agreement did not adopt the measure. However, and that is a very interesting case, now the cantons are in the process of ratification of the revised agreement. Some cantons have chosen to nonetheless adopt this criteria through their executive legislation. And yes, as I mentioned, it can only be applied within the scope of international treaties. So what exactly is the point of this? And there are, especially when it comes to complex production chains, there are high transactional costs for both sides, bidders and the government, to sort of differentiate where comes which service from which country, and to what percentage it has to be taken into account in order to get an estimation. So that's where we are. It's maybe not, I don't think it will threaten, Switzerland will not become more protectionist because of that. First, because the federation does not apply it, and secondly, the cantons might do it, but within their competence, and so there won't be any menace to international agreements. But some actors still favored protectionism, but I assume it was through quality, through the assumption that Switzerland has a very good level of quality, and if you strengthen the quality competition, then it gives an edge for the national bidders, and that is, from my opinion, is within the framework of open markets. However, it's interesting to see, because there are 26 cantons, I think 4 or 5 have adopted it, how it will develop in the future. So it's an interesting case for political science. Hence, I have finished. Thank you so much.
Thank you so much, Lawrence. I think it is bold to draw a comparison with the United States, but I think the federalism allows me to do that, or at least I think what we can observe in the United States with the Buy American legislation and the political impact it has compared to the actual impact, and then if we compare it to small Switzerland, which seems to have a very similar approach that has introduced a specific Article 29, mostly for political reason, but effectively, or the effect is zero, or nearly closely to zero, at least when we speak about contracts below 50,000, that will be a small volume that is covered, and also potentially not reaching many foreign international firms. Doesn't seem to be very attractive, at least from large multinational perspectives. So thank you very much for this comparison and for this insight into the Swiss development. I would like to give the word now to Eike Klapper. He will be sharing the EU or the European perspective on the IPI and foreign subsidies, and what he observes in the United States in terms of Buy American, Buy America. Thank you so much, Eike.
Thank you, Desiree. Hello, everyone. Yes, indeed. I will be more sharing my observations in the US, and Jean, after me, will share what she observes in the EU. We thought that this is more interesting for everyone. But at the beginning, I'd like to agree with Rob and Simon. I mean, I always join the panel when Chris asks me, but the title indeed is a bit misleading. I mean, the P word, as Simon said, I'm not sure if I would agree with that, at least for the EU measures, but in general, I think we're just living in a different time. In general, we live in a different time, but we also live in a different time of procurement. So there's a lot of changes, and also, like Rob said, I would not call them legitimate just by definition. We have to look at each one of them and then maybe see what the reasons are there, what kind of reasons they have, and how we deal with that in a global world. So I've been here for 1.5 years in Washington, DC, and just want to share with you my observation that I have in the procurement world here. And I think the first and the most important observation for everyone is to understand that procurement is a very political issue in the US. And I want to start out with 2 quotes just to give you the perspective. One quote is from the State of the Union this year in March, where the president said, and I quote, "When we use taxpayer dollars to rebuild America, we're going to buy American products to support American jobs." That's a pretty clear message, right? So that's really politics. And the second one is just a recent one, this tweet by the White House Chief of Staff, Ronald Klein, after the Inflation Reduction Act passed. And he tweeted that Buy American is not a conflicting goal with moving to a clean energy economy. It's an essential part of making that change job creating here in the USA. So it shows you that the current administration, Biden administration, is convinced that Buy American, Buy America, all those rules are not conflicting with other goals like the clean economy or working with allies. And so I have three developments I want to just shortly discuss or shortly give you an overview. So First, we start with Buy American. When the Biden administration came to office, one of the first things was to issue an executive order on Buy American to revise those rules or to review those rules. Buy American means federal procurement, right? So if an agency buys something, buys a table or whatever, that's the federal procurement we're talking about. So really at the federal level, they reviewed it for a long time, but in the end, they came out with an adoption of the thresholds. So the thresholds are rising. They used to be, or they're still 55% today. They'll change in October to 60%. They'll end up with 75% in 2029 of American-made percentage that a product needs to have if it's federal procurement. However, Desiree said it, GPA still applies. So everything above $183,000, which is the rule right now for supplies, is a GPA contract. So it's open for tender to any company from any country signatory to GPA. And also Buy American has a lot of exemptions for IT, commercially available products, minimum values, and there's a possibility to get a waiver. So the agencies can ask for a waiver. I think that's very interesting. And there's actually a website on those waivers. So if you want to check them out, what kind of waivers are granted, there's a revision period for waivers. So that's the first part. Buy American, as we mentioned, it's a question how big the economic impact actually is, but obviously from a procurement development, very interesting to see. Second one is Buy America, so without an N. And that's the procurement, or that's applies to federally financed infrastructure projects in the US. So basically, every time the Senate or the Congress appropriates money to the states to build something in infrastructure, it comes with strings attached. And those strings attached are Buy America in this case. And this used to be applicable to public works, transportation, and water-related infrastructure. But now with the Investment Infrastructure Jobs Act from last year, this is extended to any kind of infrastructure. So this also includes broadband infrastructure, EV charging infrastructure, and others. And that's a big, big change. And that's something we're following very closely. And Chris alluded to our seminar next week, which I also want to invite you to. So I'm not going to go into the details, but this means iron, steel, construction material needs to be 100% from the US, and manufactured goods need to at least be 55% US made, so the total cost. Buy America is only partly covered by the GPA. So it's only covered if that state that spends the money, that agency, is a signatory to the GPA. So that's in one of the annexes of the GPA, you can see that. So it will be very few contracts that are actually covered. One very interesting thing about this is the act itself says these rules need to be implemented 180 days after the adoption of the act, after the signature of the act. That was in May. And a lot of agencies have issued waivers because these changes have been so big that the contractors, everybody else, the states, were not able to deal with those changes in such a short time. So what we're seeing right now, and there's also a website on the Made in America Office website, where all the agencies list what they're currently doing, what kind of waivers they've been issuing. And one of the most recent ones was a proposed waiver by the Federal Highway Agency on EV charging. So they are saying we need to maybe waive those rules for a certain amount of time so we're able to implement the electric vehicle charging infrastructure that we want. And lastly, it's the newest act, Inflation Reduction Act, which we're all still reading and understanding. There's going to be a White House ceremony next week, and there's a lot of money in it for climate policy. So it's a great development, I would say. However, in certain areas, you see domestic preferences. And one of the parts I'm dealing with, the electric vehicle tax credit, where it's very clear, actually, those rules would only allow electric vehicles to be made with critical minerals from the US or FDA partners, and the batteries and the assembly needs to happen in North America. So of course, I would never dare to contradict the White House Chief of Staff, but I see a challenge here, right? Like you want to put as many electric vehicles on the streets, but then you want to make sure that only your credit tax credits go to American-built EVs. That's also another development that we're witnessing right now and following. So I'll try to be really short and comprehensive, but I think that's a bit the picture that we're seeing here. One comment is that most of those rules are really focused on the domestic market here. So it's Buy American, Buy America, and it's not so much thinking about the third countries, right? Like we heard friendshoring. There's no such rule as friendshoring and Buy America, Buy American. It's the same for everyone, right? And I'm passing over now to Jean or Desiree will. I think what we're doing in the EU are more targeted approaches at third countries, but I'll let Jean have the floor. Thank you very much.
Thank you so much, Eike. I agree. I would like to have Jean follow up directly after Eike, and then maybe we have some questions with regard to the different views that they might or might not have. Thank you so much, Jean, for being here.
Okay, thank you. Well, Eike has certainly summarized well the U.S. Buy American measures, and it's just one of what I would call unilateral measures, which are not necessarily protectionist, but they're certainly unilateral in the sense that they're outside of agreements, but mostly they've been within the constraints of the GPA. I think one thing just to note on the US measures, it has prompted action by Canada for the first time, and it's now considering sort of mirror buy local provisions that would apply in Canada, but they would also be within the constraints of the GPA. But turning to the EU, and I think the EU is in an interesting position because it's what we're looking at now is we're seeing a change in their regulatory environment. The EU has traditionally had a very open market, which means basically that any country can participate in their procurement, with few exceptions. Their utilities directive limits who can participate, or they allow them to reject bids that have less than 50% foreign content if the procurement is not covered by the GPA. But other than that, they have few restrictions in terms of who can participate. In 2019, the Commission clarified the authority of member states to reject bids from countries that do not have rights under the GPA or FTAs. But they also clarified that it has to be, the member state has to have the authority, the national authority to do so. And few member states have such authority. Spain, Estonia, Hungary, Austria, and Romania have various provisions that allow them to reject bids from countries that are not GPA or FTA partners. So what the EU was facing was a disparity between their openness and their lack of reciprocity in other countries. And China was certainly one of the countries of particular concern because there's many Chinese firms participating in EU procurement. And yet the EU, as well as of course the US suppliers, are facing many obstacles in China in terms of trying to participate in Chinese procurement. So the EU has been working on and finally this year adopted the International Procurement Instrument, the IPI. Now that was a decade in development. The Commission initially proposed it back in 2012, but the member states over the years were resisting, or some member states were resisting any restrictions in terms of procurement that would be EU-wide as opposed to just within the member state. And again, the goal I think for the EU was to find a way to promote reciprocity and sort of encourage other countries to open up their markets. And so what they finally came up with is the IPI. And I think what's been driving it more recently has been their concerns with China. But obviously it also could apply to GPA and FTA partners if in procurement that's not covered by the agreements. Now what the IPI does, and it just went into effect, I think on August 29th of this year, it was adopted earlier. It allows the Commission to, and the authority is in the Commission, not in the member states, to investigate whether a country is providing reciprocity or allowing EU suppliers to participate in their procurement. And if not, they can impose penalties. And they're still working on, I think, the implementation process. But there's sort of two kinds of penalties that the Commission can impose. One is to exclude all the bidders from that country, exclude them from EU procurement. And the second is to set up a price penalty provision. And the measures that would be adopted would be applied for 5 years. So I think the goal for the EU is not to, I think they'd prefer not to impose these measures, but they're trying to provide a strong incentive for the countries that they're looking at, that they're targeting, to negotiate a solution. Now, ideally, I think for China, it would be for them to join the GPA. But as has been mentioned earlier, China's been this year entered into its 15th year of negotiations to join the GPA. And it's made a lot of progress over those 15 years. And many of their procurement proposals are very close, or procurement coverage is very close to that of the other parties. But there's some major obstacles. And I think there's a real question whether the parties are going to be prepared in the near future to allow China in. So I think, for the EU, it's don't wait for the GPA accession of China. Take this unilateral measure. And we'll have to see sort of how it unfolds. In a sense that the IPI is a little bit like the Section 301 of the 1974 Trade Act of the US, which uses the threat of sanctions as a means of giving the US negotiating leverage to try to resolve various issues. Let me just turn now briefly to the latest proposal or measure, the foreign subsidies regulation. Now, unlike the IPI, which took a decade to develop, the foreign subsidies regulation was done in 2 years. First, the Commission proposed a white paper on it 2 years ago, followed by a proposal last year, and then this year, at the end of June, at the end of the French presidency of the EU Council, the EU Council and the EU Parliament reached a political agreement on what the regulation would be. It has not been formally adopted, but will be, I think, probably in short order. And they're looking for implementation in 2023. And what the aim of this measure is that they're looking at the EU's concern is that foreign subsidies are affecting EU procurement. That if a supplier has received a subsidy from a foreign government and is able to participate in EU procurement, it can offer bids that are below price, even below cost. This will apply to procurements of 250 million euros and above. And what it requires is it requires the suppliers participating in a procurement to notify whether they've received a financial contribution, which is very broadly defined. And then if they have, and then there's the Commission again will be the one that's doing the investigation. If they find that the subsidy or the financial contribution has distorted or will distort the procurement, they can exclude that supplier. So what we see between, actually one more point on this, the EU has emphasized that this will have to be implemented in a manner consistent with the GPA. I think this was back in their white paper. And they pointed out that one particular area of concern was the conditions for participation, a provision in the GPA. So the question will be whether the GPA parties take this up and look at it more closely. But I think overall, what you're seeing is that the EU has become, perhaps less tolerant of the procurement environment outside of the GPA, and they're looking for means of being more assertive, more aggressive in terms of tackling procurement obstacles, closed markets that they're finding. So, I think from the US perspective, I think the US would recognize that they certainly have a right to go after a procurement that's not covered by the GPA. Of course, if they decide to go after, some procurement in the US that's not covered, such as the state, which they can under this measure, that could be a concern. But the basic point is that it will not apply to procurement covered by the agreements. This is the IPI. So I think we're going to have to sort of see how it unfolds because they're just starting to implement it. Thank you.
Thank you so much, Jean, for this very detailed view on the two instruments. That was very, very helpful. I think interesting here is, again, as you just mentioned at the very end, again, that the IPI does not cover GPA contractors or member states, so to say, and signatories, but that to whom would it be relevant, right? And so China, of course, is a potential addressed party, I would say, by the IPI. And here again, we see the political noise, I would say, is there, but what does it mean in practice? And so we have heard this question many times now with regard to different of those measures. What is the real life impact of those? And that will be seen. Another thing that I think is very interesting is that the price penalties that we have heard in your presentation, and it not only plays a role in foreign subsidies, but also when it comes to for example, as we see in the post by Lawrence in the chat, also in Switzerland, what does it mean if we have an offer from a foreign firm that is very low? Does it mean that there is a price markup added, that the authority can do that in order to kind of level the playing field? Are there any exclusions allowed? Exclusions, no, but price penalty, yes. And the question is always how high. If the price penalty is so high that an offer becomes unattractive, then it's effectively, I would say, to a degree, also an exclusion. And these are thoughts that will be very, I think, that will be relevant in the future when it comes to adopting and implementing those different instruments, the IPI and the foreign subsidies agreement. I would also like to give the word to Eike if he wishes to respond to some of the points that Jean mentioned, but of course feel free to decline if you don't want to.
Never, but I think I'll pass it forward to Michael. Just one short comment. Maybe we do the seminar again in 1 year time, because both IPI and foreign subsidies should be up and running in the summer 23, and then we'll have the first experiences. But I think Michael was also here.
Thank you so much. This leaves exactly 4 minutes to Michael Bauscher. Thanks so much, Michael, for sharing your perspective.
Hi, Desiree. Thank you very much indeed. I kept my my content. Gosh, Chris has put more bullets in there than I think I had to start with. Chris has expanded my content, but I'll pick the highlights from the menu above. As I said there, policy or just picking fights. We're obviously, the government here is trying to find its way in procurement, international procurement policy. And I'll try not to be too judgmental. Some of what it does is quite intelligent, and some of it is more rhetoric. Inevitably, there's quite a bit of rhetoric, not least because buying British was a slogan in the Brexit campaign, and therefore those associated with that have to at least to some extent wave that flag. It's a bit embarrassing that the last act of the Johnson government was to buy Audis for the government ministers' cars. But there we are. But that perhaps reflects the inevitable compromise forced upon them. I also will avoid the P word, because I think policy, in fact, is very open, but that, as there's a resonance with a lot of what has been said by others, as other policies, as we move away from the sort of the old 1980s pure internal market sort of rationale for procurement law and start to explore the development of a range of other policies, inevitably some local advantage, if I put it that way, without even using the word preference, starts to creep in, whether that's in the social area, in sustainability. And here, of course, there's very much the policy of localism has been part of our law since 2012, when authorities were been expected before putting out any public contract to consider how that contract would bring benefit for the relevant local community. And that cranks up again more and more. We now see, again, in sustainability as well, greater expectations to meet the relevant sustainability agenda goals. And of course, in some areas, food is the obvious one, but in others, sustainability goals can also meet a localism agenda, which can be perceived to be at the very least non-neutral from a trade perspective. Leveling up, of course, again is very much that does, to use one of our former Prime Minister's favorite phrase is that gives rocket boosters to the localism agenda, because government bodies, local and central, are expected to think about how public money spent through procurement can generate advantages for parts of the country which are seen to have are said to have been to some extent left behind. And that is reflected in what we now have as the National Procurement Policy Statement, which is now a regular document, regularly updated, which requires public bodies to consider national priority outcomes, including the creation of new businesses, new jobs, and new skills. Let me try and that will be given in the new procurement bill, which is under discussion. That will be given a legislative power. Authorities will be required to meet the requirements of the National Procurement Policy Statement. So there will be some force in having to meet these requirements. But on the other hand, the economy remains very open. It has to be, because large swathes of the public sector economy are dependent on non-UK and in fact indeed non-GPA suppliers of services particularly. And in the new procurement bill, perhaps what one sees is again a very much an open textured, an open market approach, limited only to the extent that it really resonates with what's already been said about the US and the EU. And perhaps the key change is the fact that bids may be deemed unsuitable if they come from what's called non-treaty state suppliers, which means those entities which are either not members of the GPA or don't have some other bilateral trade arrangement with the UK, incorporating some procurement component. And two things to be said about that. Firstly, that is, some have perceived that as being protectionist. I don't think that's really right. I think that's just catching up with what is the modern vogue and trying to, as Robert Anderson has put it, leverage people into the UK's mini version of the walled garden, the walled nursery garden. But also, the one novelty about this, perhaps, I'm not sure if it's a novelty, but one oddity which has been particularly picked up upon is that this is extended to subcontracts, so that a tender that may come from a treaty state supplier, but if it is seen that that it's relying on subcontracts from outside its treaty state suppliers, then that may also be a ground for the tender to be disregarded. Where will this all go? I think there is going to be quite a bit of hot air expended on this. And just to touch at the end, I'm not sure how much I can say about this, because I've identified the first UK-EU WTO dispute in the bullets, and I've been trying to work out what is and is not in the public domain. In short, there has been the first WTO dispute was about, between the UK and the EU, was about local content requirements in the construction of offshore wind farms, which the EU in its formal filing said were imposed by the requirements of the licensing or the regulation of suppliers opening up new offshore wind farms. That dispute is not going anywhere. And I think all I will say is that the supply chain guidance which was tied into that and which was the part of the complaint has changed, but do look it up. It changed a few weeks ago. The explanation I saw for why the EU is not pursuing this claim struck me as a little surprising. And I think that really just goes to remark that's already been said. There's quite a lot of hot air here, but in the end, I think different officials have to be a bit careful what they say about each other, because there's an element of they're all at it. And some of the things which some people are accused of doing, it turns out on a bit of careful exploration may not be the cleverest thing to accuse someone else of doing. Thank you.
Thank you very, very much, Michael. We have reached the end of our hour. As usual, we have so many more questions we'd like to ask and answer, but we don't have the time. I really appreciate the very insightful presentations that all of our moderators and panelists have contributed. Thank you very much to the members of the audience who asked a number of very interesting questions. We respond to those along the way, and we also posted in the chat further information that you hopefully find useful. The video of this will be available on Desiree Klingler's website, will be available on the program page, which is cited in the chat, and will also be available on the YouTube page for GW Law School's Government Procurement Law program later today. And then again, we're going to be having a program on September 13th on the Buy American provisions. Information on that is available at this website here, and I'll be putting a link to this program onto the program page for this program as soon as we sign off today. Again, thank you very much to everyone who participated, and have a great day. Take care. Bye-bye.
Thank you. Bye.